So, what's up guys? So, mag-vlog taron no para sa ato ang grado sa law kay isud na jud. Vlog lang gud ta mas hindi ta vlogger pa baga tag naong kay para sad makapasoy ta para ma-appreciate tong sir ba kay appreciate ni sir tong effort ba. Ay na lang basin dai pasalon ta sir mas kintos na gud, sir. So, nga ni di atong suot ron no kay gikan minanimba kay Pasko beron. So, mas Pasko kinda ko mag-vlog jud ta kay para sa tong grado day. So, wala lang. Wala to share ko lang akong suot. So, ato nang sugdan kay aron sa'yo ta mahuman. What's up guys? So, gamit ani no? Para kay protection ba? Protection. Kay nabi daw kuan karon delikado ba patato karon kay ay COVID oy. Dapat magamit og protection. So, atong unang article no kay Article 1845 which talks about the limited partner's contribution. So, what's man yung limited partner? So, a limited partner is a partner who is not personally liable for the obligations of the partnerships. So, a limited partner is merely an investor. Diba niya? Merely an investor. So, muhatag siya cash or butang sa partnership, but he does not participate in the management of the partnership's affairs. He does not contribute industry. Once he contributes industry or services to the partnership, he, the limited partner, will be considered as a general partner, in which case he will not be exempted from personal liability. So next is Article 1848, or the liability of a limited partner for taking part in the management of partnership. So just like what I have said earlier in Article 1845, a limited partner is merely an investor. He should not contribute industry, and taking control of the business is a form of contributing industry which is bawal. So, but when a limited partner becomes involved in the management of the firm's business, then he will be liable as a general partner. So, pagbalik ka no? So, unsa man ang consequences if liable as a general partner? Ang consequences anak kay the limited partner will be liable to the extent of his personal liability, or the subsidiary liability which is applied to the general partners will also be applied to the limited partner. Sabot? So next is Article 1851, so which talks about the rights in general of a limited partner. So if you will notice no, magbalik rin siya. Sana all mo balik oy. So limited partner is merely an investor. He is viewed as a partner only to a certain extent. His powers are much more limited than those of a general partner. So as between the members of the firm, the limited partner, in order to protect his interest, has the same right to compel the partners to account as a general partner has. So, unsa may rights niya? So, the rights of the limited partner are in reference to being an investor. A partner is a co-owner of the partnership properties via, and that includes the books of the partnership. So, right niya mo tanaw sa partnership books, but limited only to reasonable business hours and demand true and full information of all things affecting the partnership. Kaya investor man siya, so right na niya. So, unsa man yung partnership books? So, book ni siya sa partnership, and example ani kay like financial book which includes the balance sheet and the income statement. Pwede sa the articles ani. So, the question is, where man ni ibutang? As ibutang ni sa principal place of the business of the partnership and not sa principal office. So, right niya na ipakip ang partnership book at the principal place of business of the partnership para ma-inspect niya. Also, he has the right to formal account, but limited only as it cannot be asked anytime, only when i-dissolve na ang partnership or kung ibalik na ang iyang investment. So practically, you will notice na these rights enumerated are rights of an investor. So, Article 1852. So, status of person erroneously believing himself to be a limited partner. So, unsa may pasabot ani? So, kani siya, na ay partner na nagtuo siya na limited partner siya. But actually, general partner day siya. But unsaan man ito pagkabalo kung unsa jud siya actually? Well, there are two ways para makahibaw ta. First is based on how he acts. Ni-participate ba siya sa management or wala? If ni-participate siya, in which case, he is a general partner. And second is according to the certificate or sa articles. If it was stated there na general or limited partner ba siya. So, mao to ang partner, nagtuo siya na limited partner siya, but on the record, general partner siya. So, iyang actuation kay is that of a limited partner, wa siya ni take part sa management. Otherwise, with good faith or bad faith, he is considered as a general partner because once he participates, he immediately becomes a general partner. So, ato balikon ha. ang partner, gatuo siya na limited partner siya. His actuation is that of a limited partner, but on the record, sa articles or certificate, nakabutang dito na general partner siya. So, is he considered as a general partner? Is he liable as a general partner? Well, it depends. Nga naman, because at the moment, nakahibaw siya na general partner day siya in record, he should renounce all his interest in the profits of the business or other compensation by way of income. Or kung naaman gali siya'y madawat na profit, di siya mudawat. Or kung makadawat na siya, iya ay uli in the meantime until na ma-adjust ang records niya to reflect that he is a limited partner. So nga naman di niya dawaton or iuli ang profits. Because on the record, general partner man siya and ang sharing of profits niya kay general. So he must not accept that. So, dapat iuli niya or di niya dawaton. But it does not mean na di na dyan siya kadawat of profits. When the records is adjusted na, then he will receive his share, even previous shares niya, as a limited partner. Gets? So, Article 1853, both a general and a limited partner at the same time. Pwede din, no? Ikaw isang katao pero magduha ka mo responsibility kay duha ko ba? So, unsa man ni siya? A person is a general and a limited partner at the same time. So, unsaon man na siya? Miss, ingon ka miss na kung mo take sa part sa management kay automatic na ma-general partner. So, first of all, to be a general partner and a limited partner at the same time, it must be stated in the certificate of partnership or articles of partnership. And unsa may consequences ani? Well, generally, his rights and powers are those of a general partner. Hence, he is liable with his separate property to third persons. However, with respect to his contributions as a limited partner, he would have the right of a limited partner insofar as the other partners are concerned. Iyang liability sad kay limited resad as a limited partner. So, what does it mean na limited iyang liability as a limited partner? Limited iyang liability to the extent sa ilang articles of partnership, like between niya o sa laing partners. But as far as the public is concerned, he is considered as a general partner. So if he is liable to third persons, he has the right of reimbursement from the other partners with in reference to those liabilities. After all, stipulations limiting liability is valid among partners even though it is not valid as to third persons. So next is Article 1855, which talks about preferred limited partners. So diri, pwede na i-category sa limited partner. Like for example, si Miss Sexy, preferred limited partner siya with regards to surplus or return on capital. So pwede na siya. As long as these preferences are stated in the articles of the partnership or certificate of partnership. So in the absence of such statement in the certificate or article, even if there is an agreement among all partners, all the limited partners shall stand on equal footing in respect to these matters. Mura, ragod og sa eskwelahan ba, dapat equal og paghatag grades, di kay na preferences or favoritism ng mga ubang teachers ba. So, dapat equal jud, no? Charot. Next is 1860. So, effect of retirement, death, insanity, insolvency, o unsa pa na diha sa general partner. So, the retirement or withdrawal, death, insolvency, insanity, or civil interdiction of a general partner dissolves the partnership. But no? But the dissolution is di mahitabo if the business is continued by the remaining general partners. So if the remaining general partners continue the business under the right given in the certificate or with the consent of all the members, the certificate must be amended. Paita ni nga tayo ilong oy kasi kaho. So now let's move on to law on private corporations. So, Section 3, Classes of Corporations. So, the Corporation Code classifies private corporations into stock and non-stock corporations. Corporations which have capital stock divided into shares and are authorized to distribute to the holders of such shares of dividends or allotments of the surplus and profits on the basis of the shares held are stock corporations. So, unlike stock corporations, non-stock corporations do not issue stock and are created not for profit. It is one where no part of its income is distributable as dividends to its members, trustees, or officers, provided that any profit the corporation may obtain as an incidental to its operations shall, whenever necessary, be used to further the purpose for which the corporation was organized. Section 5, corporators, incorporators, stockholders, and members. So in here, we're talking about unsa incorporators, stockholders, and members. So basically, we're talking about the components of a corporation. Corporators, so kining corporators, they are the persons who compose the corporation. So whether as stockholders or as members. Kining corporators, apil ang incorporators ani. They are the corporators who are mentioned in the articles of incorporation as originally forming and composing the corporation and who executed and signed the articles of incorporation. So all incorporators are corporators, but a corporator is not necessarily an incorporator. Gets? So, stockholder. So, kaning stockholders, mauni sila ang owners of shares of stock in a stock corporation. Thus, they are also called shareholders. So, and getting members, they are those corporators who compose a non-stock corporation. So Section 10. So Section 10 provides that the incorporators must not be more than 15 persons and all of legal age. Another qualification is that a natural person who is licensed to exercise a profession shall not be allowed to organize a corporation unless otherwise provided under special laws. Also, the code now expressly requires that each incorporator of a stock corporation must own or be a subscriber to at least one share of the capital stock of the corporation. Furthermore, in the old corporation code, there is a question as to whether an artificial being could be a corporator. So now, in this new corporation code, the juridical person or artificial beings like a corporation or a partnership can now become incorporators. So in the old corporation code, said, di pwede na isara ang corporator sa corporation. Dapat at least 5 jud. But now, pwede na isara ang corporator. That is why na ay one-person corporation which is a corporation with a single stockholder. Makita jud nato na naay dako na changes, no? So, the purpose of this amendment is to encourage more business. Kaya naa jud mga tao na mahalok ma-engage in business because of liability. Kaya for example, si Guapo na ay sari-sari store. Then, ang utang sa sari-sari store, liability sa di Guapo. So, that is why the Corporation Code was amended to encourage a limited liability to enjoy the protection of the corporation by including a one-person corporation. Section 17, change of corporate name. So, a name is peculiarly important as necessary to the very existence of a corporation. Its name is one of its attributes, an element of its existence, and essential to its identity. So, the general rule as to corporations is that each corporation must have a name by which it is to sue or be sued and do all legal acts. So as far as the law is concerned, if may non-galitag distinguishable, dapat di pari-pariha sa name sa laid. It also includes the names na pari-pariha og sound. Example, ana kay maghimo ka business niya ang name kay Jolly Baby. So di na pwede kay possible na it is not distinguishable from Jollibee. So thus, the incorporators may choose or use any name they may see fit, provided that it is one not identical or with similar to a name which was previously adopted or which is being used by another corporation as a trade name or is contrary to existing laws, rules, and regulations. If the corporation fails to change its name gali, the SEC may hold them in contempt and pwede sila mapapriso sa SEC and pwede sad ma-revoke ang registration of the corporation. Section 18. Registration, incorporation, and commencement of corporate existence. So, ganus aman ma-commence ang existence sa corporation. A corporation commences its corporate existence and juridical personality and is deemed incorporated from the moment the SEC issues to the incorporators a certificate of incorporation under its official seal. So, Section 33, disloyalty of a director. So, under this doctrine, a director who, by virtue of his office, acquires for himself a business opportunity which should belong to the corporation, thereby obtaining profits to the prejudice of such corporation, is guilty of disloyalty, and should therefore account to the latter for all such profits by refunding the same, notwithstanding that he risked his funds in the venture. But, no? So the guilty director will be exempted from liability to the corporation if his disloyal act is ratified by the vote of the stockholders owning or representing at least 2/3 of the outstanding capital stock. So Section 44, Ultra-Vires Acts of Corporations. So what is Ultra-Vires Act? The term Ultra-Vires refers to an act outside or beyond corporate powers, including those that may ostensibly be within such powers but are, by general or special laws, prohibited or declared illegal. So the Corporation Code defines an ultra-vires act as one outside the powers conferred by the code or by the articles of incorporation, or beyond what is necessary or incidental to the exercise of the powers so conferred. So for example, a corporation was organized for the purpose of engaging the buying and selling of home appliances. So the act of buying and selling a car would be ultra-vires, although it is itself lawful because it is outside the object for which the corporation is created and therefore beyond its powers. So Section 59, Subscription Contract. So Section 59 lays down the rule of what shall be deemed as subscription. So under the former law, if the acquisition of unissued shares from a corporation is made after its incorporation, the contract is either a subscription or a purchase of stock depending upon its terms and intention of the parties. So this new corporation code abolished the distinction between the subscription and purchase of shares from an existing corporation by making all such acquisitions a subscription, notwithstanding that the parties denominate it as a purchase or sale of some other contract. Section 64, Liability of Directors for Watered Stocks. So, unsa man ning watered stock? Tubig nga stock? Charot. So, watered stock is a stock issued for no value at all or for a value less than its equivalent, either in cash, property, services, or stock dividends. So, as a general rule, the obligations incurred by the corporation acting through its directors, officers, and employees are its sole liabilities and vice versa. However, there are some circumstances where solidary liabilities may be incurred, such as when a director or an officer has consented to the issuance of watered-down stocks or who, having knowledge thereof, did not forthwith file with the corporate secretary his written objection thereto. Thus, the liability of the consenting director or officer for the issuance of watered stocks is solidary with the stockholder concerned. This means either of them can be held liable for the whole amount of the difference. Note that the fair value of the stock is determined at the time of its issuance so that the subsequent increase in value of property given as a consideration will not eliminate the water-in stock and relieve the director or officer and stockholder from liability. So Section 65, Interest on Unpaid Subscriptions. So in the meantime that the inter amount on stock subscription has not been paid, subscribers for stock shall be liable to the corporation for interest from the date of subscription, but only if so required by the subscription contract. If the rate of interest is fixed in the subscription contract, then such rate shall be paid, otherwise such rate shall be deemed to be the legal rate. So Section 70, or Effect of Delinquency. So stock delinquency does not deprive the holder of all his rights as a stockholder except the right to vote and to be voted for, or to be entitled to representation at any stockholders meeting and as provided in this code. However, he shall still be entitled to receive dividends. Section 71 talks about rights of unpaid shares. So before unpaid shares become delinquent, the holder thereof is not considered to have violated any contract with the corporation, and therefore, he has all the rights of a stockholder, which rights include the right to vote. Such rights commence from the time his subscription is accepted by the corporation, or if the offer to subscribe is made by the corporation from the time such offer is accepted by the subscriber. However, he is liable for the interest on his unpaid subscription if so required by the bylaws. Section 84 talks about who bears cost of appraisal. So as a general rule, the corporation shall bear the cost of appraisal, pero nanay siya exception. Unsa man? So, the cost of appraisal shall be borne by the stockholder if the price offered by the corporation is approximately the same as the fair value ascertained by the appraisers, or when the same action is filed by the dissenting stockholder and his refusal to accept payment is found by the court as to be unjustified. So, Section 86 talks about the definition of non-stock operation. So, ato naman yung kuan ganihan, no? Ato naman yung istoryahan ganina. So, balik-balik kayo ni siya. So, non-stock corporations do not issue stock and are created not for profit. It is one where no part of its income is distributable as dividends to its members, trustees, or officers, provided that any profit the corporation may obtain as an incidental to its operations shall, whenever necessary, be used to further the purpose for which the corporation was organized. So the fact that a non-stock corporation earns a profit does not make it a profit-making corporation, where such profit or income is used for purposes set forth in its articles of incorporation and is not distributed to its incorporators, members, or officers.
I like to party!
Section 17, minimum capital stock not required for 1% corporation. So, sex na jud. Self-explanatory na jud siya. So, as a general rule, a one-person corporation shall not be required to have a minimum authorized capital stock unless it is provided by special law. Next is Section 119 or the bylaws. To sex gyapon ni. The one-person corporation is not required to submit and file corporate bylaws. Only articles of incorporation is needed. So, take note, only articles of incorporation is needed. So, Section 120 or display of corporate name. So, the letters OPC should be indicated by the one-person corporation either below or at the end of its corporate name. So, Section 148 talks about amended license. So, this section requires a foreign corporation authorized to transact business in the Philippines to obtain an amended license in case it changes its corporate name or it desires to pursue in the Philippines other or additional purposes. So, in the first case, a foreign corporation obtains an amendment license in case it changes its corporate name. The amendment is necessary because the foreign corporation is authorized to do business under its original corporate name as stated in its articles of incorporation and not in its new name. And in the second case, only for the purpose or purposes specified in such license and not for the other or additional purposes, that the application for an amended license must be submitted to the Securities of Exchange Commission favorably endorsed by the appropriate government agency in the proper cases. So, muna na to siya guys. Nahuman na ta. So, may naroon mo yung nakatunan, no? Oh, okay na sad na mo yung katunan. Pero, mas okay siya na mo yung makatunan kay appreciate ni sir atong kwan ba? Atong effort na namin nakatun sa ako. Char.
Wah! Me and my jowa. Wah! Uuwi na siya. Wah! Magkahanap ng iba.
Wah! It's me and my tunanan. Wah! Mamas ko sir. Wah! Dos lang sir. Wah! Papasarami sir.